Good morning. How you doing, guys? Good. Thought we were going to have a deposition this afternoon, but it looks like at least that's delayed, so we'll see what happens once we review the affidavit, which we haven't yet. And got a trial date coming up, so we got a lot of work to do between now and then.
Do you feel you got a fair shake from the judge? I mean, is it possible but difficult, or?
I respect her ruling. I think that there is an enormous amount more work to be done than will and can be done between now and June. It's just, I think it's physically impossible for us to be properly prepared. I can't make believe that the bases for the motion to continue and everything that was contained in it don't exist. And I don't know how, I don't think we're going to be ready.
Do you have any remedy beyond what happened today then?
We respect her ruling. I'm going to look at it. We're going to do some research on it. But no, as of right now, she set a trial date. I was concerned that I didn't want the misassumption to be there that we agreed to June in the beginning, because we never did. And once I cleared that up, she didn't change her mind. I'm okay with her ruling. I just don't know how we're going to comply with it.
Do you have a remedy to appeal it through the WCA or something? Do you have
I don't think that the denial of a motion to continue is a proper grounds for an interlocutory appeal. I'm not certain, but I don't think it is.
Does this set you up for an appeal if Zimmerman is convicted?
Well, should there be a conviction, which we don't believe will happen, but should there be one, then the appellate court would have to review the basis for the conviction, and that will include what was and wasn't presented at trial. And that sort of backs into whether or not we had adequate time to prepare for it based upon everything that we filed, because now all of our motions concerning discovery issues that we've had, I think, become even more relevant if we are now at the courthouse doorstep and still not ready.
Do you think the state is playing games?
Literally, what I said in my motion, I guess is the best way to say it. They've taken a very formalistic approach to discovery. It is different than that which I'm used to. Normally, what I do is if there's a problem with discovery, make a phone call and try and get it resolved. But, I also know what people are saying. They're just saying, here we are, just delaying the inevitable. Some people will say if they think he's going to get convicted, delaying the pain the family is going through. But I've got to look at it from a criminal defense attorney's perspective. I want to try this case once. I want to try it right. And Mrs. Zimmerman deserves a Sixth Amendment right to a fair trial with good, zealous representation, and that takes time. I mentioned the attempted murder case for a reason. That case here in Seminole County, a cop was shot, and it was 3 years ago, and it's now going to trial. Now, I don't know if there was untoward delays, but we are less than a year from the event, less than 10 months from my entry into it. I do not, and I'll show you the time I've spent on it. We are busting butt on this case, but we need a lot more work to be done before we're actually ready for the trial. That's all.
Do you have anything to say about the cell phone records and the GPS movements that you don't have for Trayvon's phone for the day of the shooting?
The motion reflects that the GPS documents support GPS locations for all of the days except for the 25th, all the days he was in Sanford, 26th. And then there's nothing on the 26th. We have just now gotten those. We have not even gotten an expert to review them. And now, quite honestly, without funding, we can't afford to get an expert to look at them. So that's the conundrum that we're in. Unfortunately, we're going to now be trying this case without the experts we need to try it right. And maybe an appellate court will look at that. We'll see.
Can you file for indigency? I mean, you've talked about that you can get experts and have to see.
It still is on the table now with the accelerated schedule. I don't know how we're going to address that. There's a lot now to reconfigure as we try and work through it.
When did you get the cell phone records leading up to the 26th, and when did you get the 26th records?
We got the first round when we coincidentally found that FDLE had actually done an analysis. We then got those a few months ago, 3 months ago, I think. Then, when the phone went up to Cellbrite, we got those records on January 15th, 2 Fridays ago, I believe it was. That's when we got the second report. It was in that second report that we see that the GPS records exist for up to the 25th, but not the 26th. And also it seems that there are some text messages and or phone calls that from other sources we think existed, but do not show themselves in that report.
So what do you do with
I want someone to explain the whole. I want someone to come in and tell me why there isn't GPS documentation for the 26th. And then we'll see.
Mark, you said you couldn't meet the deadline for, I guess, notifying the state and the court of who your experts will be. You're not going to be able to make that deadline. Is that because of lack of money?
It will be lack of money, I think, absolutely. It has been the fact that we need to have the evidence before we pick an expert. I've used the example of a medical, analogy, but you don't pick your surgeon or your specialist until you do all your workup. You do your x-rays, you do your blood tests, you do your medical reports, and you say, okay, this is what we have, this is the expert who's going to best address that. We are still getting our x-rays and our lab tests and our blood work, and we are just not ready to pick specialists yet. You would want it done medically or legally, and George doesn't want it done, and I don't want to do it that way.
So are you just conceding you're not going to have these experts then? You just said you can't meet the deadlines. Was that it?
I know how to zealously represent a client, and we're going to continue to do that between now and June. If you told me right now, can I build a 14-story building between now and June, I would tell you no, cannot do it. We're going to see what we can get done between now and June, but my timeline for what I know better than anybody else besides Mr. West as to what has to happen in this case, I do not see that happening properly between now and June. That's just where it is. But that's the trial date, so we'll try it then, unless it gets changed.
Would you consider asking again for a continuance down the road?
I would imagine that we're going to have to revisit the issue of whether or not this case can actually be tried in June, and then, of course, it'll be up to Judge Nelson.
What do those 7-Eleven records give you, and why do you want them?
7-Eleven records would give us information of other people who were there. The videotape shows there were at least 3 other people, and it looks as though close analysis of that might suggest that there were interaction between those 3 people and Mr. Martin. So we want to look into that.
So you want to identify that person who you think talked to Trayvon in the store?
Yes, or the several of them.
Mr. Crump is saying in his affidavit that the reason there seems to be a gap in the recording of Witness 8 is because he was stopping and starting the recorder, because he gathered his thoughts for the next question, and to switch cell phones to see which one had the best audio. Does that seem reasonable to you?
If it was me taking this statement under that unique and awkward set of circumstances where you're talking about a primary state witness, if not the most significant one, what I would have done was I would have had a video camera running that never would have been turned off. I would have had an audio recording that never would have been turned off. And then if I wanted some third recording that I wanted to stop and start no less than 7 or 14 times, I might have done that. But what I would have done was protect myself and insulated the validity of the statement from second guessing and attack based upon the fact that we now have 14 minutes or 13 minutes of conversation and 26 minutes worth of phone call. And that is very problematic from an evidentiary standpoint and just from a practical standpoint. I think everyone sitting here would have handled it in a way that probably would have been different, particularly when there's 9 or 10 cameras and we know there was a camera there. So I would have done it differently.
To get rid of that statement?
We'll
Does
see.
it matter?
No, I think because there are such inherent problems with the statement that it's going to be subject to what we call motions to suppress, potentially. But we'll see. I don't know yet because we're just now getting that information.
But she can repeat the same thing to you now in a deposition, right? Or
well,
on the witness stand. I mean,
yes.
She can repeat all of what she said. So
Yes,
is that
she
a
could.
problem?
Well, there's 12 minutes of what I don't know she said that I don't know if she'll be repeating them properly, right? I mean, if we have a 26-minute phone call and maybe she was placed on hold, none of which I know, then I would want to know what else was being said, only in the room with the other 8 people or 7 people and with her. And again, that's what discovery is for, and we'll get to it.
Have you gotten do you know whether ABC has recorded the whole thing uninterrupted, and where does that stand getting that?
I don't know. We are going to have to set that hearing. They're going to resist it based upon the Shield law, as I'm sure everyone here is familiar with. I think it is the only available source for it, and we'll argue to a judge. I would imagine if anybody with a camera here was in that room and was not prohibited from doing so, and we have no evidence that Mr. Gutman and ABC was, that they would have their recording devices on. I would. So if it's on, I think we should get it. I think it's my client's Sixth Amendment right would trump both the Shield law and any other suggestion that we shouldn't have such critical evidence. We'll see how it goes.
The evidence that you have
you mentioned
recovered.
the significance of Trayvon Martin's, what would have been Trayvon Martin's birthday today. Can you talk a little bit about that here outside about that?
Look,
today?
we are, we're humans. Lawyers we're called gladiators. You come to us with an issue and we deal with it as best we can. We're supposed to be rational. A doctor is not supposed to be afraid of blood, and he's not supposed to be afraid to tell you when you have an illness. And lawyers take on a certain armor for that. But let's not forget the reality that no matter how it happened, tragic as it was, the 17-year-old lost his life that night. And we don't need to ignore the reality. If today's his birthday, I lost my mom, I lost my dad, I lost a nephew at 35, I lost a niece at 13. I remember their birthdays, I remember their losses. I don't think that we need to be disconnected from the tragedy that happened to Trayvon Martin, even if it's our position that he caused it himself and that it wasn't George's fault. Nonetheless, a 17-year-old driving down the street doing 70 miles an hour may have caused his own death were it to happen. It's still a tragedy. We're just acknowledging that. It doesn't, minimize what George felt he had to do that night, to acknowledge that we didn't need to lose Trayvon that night. The intersection caused it. We know from the evidence that George was the only one with injuries and that his nose was broken, smashed, fractured, whatever you want to call it, and that seemed to be caused by Trayvon, and that may have been what led this thing down a path where he lost his life. But the loss of the life is still tragic, and that's all I want to acknowledge.
Are you still planning on the immunity hearing motion that would happen probably in April?
Yes, the immunity issue still has to be addressed by the court. We haven't decided exactly when or how.
Are you still confident after today that you'll be amply prepared?
We have a lot of work to do in much less time than I need. So we're going to have to deal with that.
If you lose that, though, you can actually appeal that, Mark, and then you can get some more time, right?
That is correct.
Interesting.
Are you definitely
Not the first
going to
time I had
file
thought
for
about
that
that.
hearing?
Sorry?
Are you definitely going to file for a self-defense hearing?
We haven't made that final decision. We now have a much more accelerated schedule to deal with that, so that may impact that decision. Don't know yet. The concept of self-defense is completely within the fabric of this case. It is the defense. Whether or not that is a separate hearing or whatever, we know that George Zimmerman is going to present a defense that says he acted in self-defense and that there's the support for it within the forensics, and we'll work through that.
What's the status of the defense fund?
Oh, a few $1,000s, less maybe, in dire straits. I don't know exactly what we're going to do about hiring experts without money. I will say one thing, I don't personally have the money to do it, so I don't think that's an option. I don't know exactly what to do. It's really frustrating that we are now sort of in the middle of getting ready for a trial with inadequate funds and inadequate assistance. But, this case always has a very unique twist, and that's another one.
You're not going to file for indigency?
I don't know. We may have to. I don't know what.
What are you waiting? I guess what I'm asking. What are you waiting for if you have that situation where you don't?
At this point, I think we're getting, not to sound coy, we're getting much, much closer to having to seek state assistance in providing for George's defense, because it doesn't seem like it could be provided for any other way unless things change with the defense fund. So there are problems with that, of course. Living expenses aren't covered and whatnot. I don't know what George will do, but, we have to deal with it.
And are you worried about the financial limit to how much you can spend on an expert, therefore maybe not get the expert you want?
I'm very concerned that we will not have the money and the wherewithal, and now the time, to properly bring in experts to assist us in a case that not only should have, but demands experts to explain away matters like the forensics. The gunshot is an issue, the audio, obviously the voice, the audio is an issue. And there's several other experts that if I had this case being handled the way I wanted it to, they would already be involved in the case.
But I mean, if you file for indigency, then you're limited to how much you can pay. Then
That's
it may
correct.
limit your choices. Is that part of the reason you're not doing this yet?
Yes, it is. Okay, guys.
One quick, how much more discovery do you need now? I mean, are you in a good position now where you can move forward, or are you still fighting with the state?
Well, you know, I'll give you an example. When we finally got to FDLE on January 9th, after you've read the motion, you've seen all my complaints about the way it's happened, they said they gave it all to us in front of the judge, then 2 weeks later we got more, and then then we go to FDLE on January 9th, what is that, less than a month ago, and we find a bunch of evidence that we didn't have before, including reports concerning Trayvon in Miami that they had since March, including a map showing us where Trayvon's cell phone was that day that they had since March. So, and a bunch of other information. So, do I have enough discovery? I would have thought that by now I had every sheet of paper, but I keep finding out that's not true. So I don't know. I would like to be able to say to you, I have all the discovery, I'm done, now I just got to get ready for trial, but the frustration for the past 8 months with this case is that we don't know what we don't have, and they won't tell us. So
I'm clear, you said the map of where he was that day.
Where his phone was.
Where his phone was. So they knew in March where his phone was? That's what I'm trying to get.
Here's what we found. On January 9th, we found a document that seems to suggest where Trayvon Martin's cell phone was, bouncing off different cell phone towers in that area during the relevant time. We just saw that on January 9th for the first time. What's interesting is that we never got before, right? So there's one piece of evidence. Second piece of related evidence is when we do get the cell phone records, what's missing? The GPS coordinates for where his phone was that day. So hopefully that's just a coincidence. Okay, thanks guys.
Thank you, Counsel.